showing up in their cars. So it's not the idea that it's some sort of large burden on the officer, but it's a burden that the defendant should be easily able to bear. Just strange credulity. It's not reasonable. It's not fair. And like I said, in this case, there's no real argument in favor of continuing to detain Mr. Curry after they've already had 2 shots at him. So for those reasons, John, I would ask to dismiss.
Okay, let me push back on you, Mr. Rogers, before Ms. Freeman gets a chance to respond. I have the first warrant number that I see is 2022 CW 50361, charged with simple assault, family violence.
Well, Judge, and that one's not related to the felony.
No. I'm going somewhere with this, Miss Freeman.
Okay.
So let me get there, Miss
Okay.
Mary. That's why I say you like Miss Mary. You stopped me from.
Oh, all right, Judge. I'm just trying to keep you on track. Okay.
Oh, okay. So we have 2021 CW 51194, charged with robbery. 2021 CW 51195, charged with battery, simple violence. And then WA of 2022 WA 07494. So it appears to me, Mr. Rogers, that there are 3 separate incidents involving your client.
Actually, it'll be, you said 3 of be the robbery and the battery are all part of the same allegation about the phone. That's a simple battery that's alleged as part of the robbery. The 2021,
which I'm
51.
Which I'm counting. I'm counting those 2. And correct me if I'm wrong, but I see 3. If I count those, it's four counts. But I've placed the robbery and the simple battery with the CW 51194 and CW 51195 together.
Okay.
So I've counted those as 1.
Okay.
Okay, I've counted those as 1, but I also have 2022 CW 50361, which is listed as simple assault. And I have a WA of 2022 WA 07494, which is the date that I believe maybe the May 4th date when you're saying your client was arrested. Okay. So what I'm looking at, and I'll give you the time to respond, is it looks like there are 3 situations that are open and pending. And they're all simple assault, robbery, battery, simple family violence, and criminal trespass. And I'll give you your argument on the robbery, because I do understand how that gets charged, where somebody takes the phone or whatever, and it's done in the heat of passion. So, what do I see, Mr. Rogers, if I let your client out on the street today, that he's not going to be beating somebody up against the head tomorrow?
Well, I would, just a couple of things I would say. And let me be clear, and I'm only saying this just so you know everything. Like, we don't actually represent him on the misdemeanors, but what I'm looking at, it looks like we might have, I guess at the time, maybe we weren't aware of the separation of them all. So, but we do actually have documents. I'm looking at the criminal trespass, for instance. It looks like he's just saying that he locked somebody out, apparently maybe of their own location or somewhere they reside on a criminal trespass. There's no violence alleged. Additionally, I would say with the simple battery, I would keep in mind that does not require any sort of injury, even necessarily force. I mean, if technically, anytime you touch somebody without their permission is a simple battery, as long as they're not cool with. It doesn't have to harm them.
That's true, and that's why you don't touch somebody without their permission.
I would agree, Your Honor, but I would just point out that it's not necessarily, it does not require a violent act, is my point, as in, it does not require an intent to harm anyone or to do any sort of anything coercive or threatening or anything like that. So I would say that anytime we're talking about like a simple battery, let me be clear, I'm very big on don't touch me. You know, I understand. I do get that. So I don't mean to completely dismiss it, but I would say it's not the same as an act that requires essentially somebody to inflict an injury upon someone. I will point out that as it relates to the simple battery, in this case, like I said, the alleged victim, I've spoken to her on one occasion at length. This was not something she was concerned with. Like, she seemed more annoyed to have to respond to the process of it than anything related to the allegations. So that's what I would say about the simple battery as it relates to this one. Like I said, the criminal trespass, that doesn't really involve even any damage alleged. It just seems to be more of an interference with somebody's access to property. It's not even alleged damage. So for those reasons, I say that at this point, I don't think we really have anything that in these charges will raise any concerns for anything like that. I don't know. I'm trying to see if we have any info on the other one that we don't actually represent them on, just to see if I got any information about it.
Well, Judge, the charges that really are not before the court should just be placed on a misdemeanor calendar. And then at that point, Lister and Holt will be representing the defendant unless he hires counsel. And so the only charges that are before the court is the robbery and the battery. I will say that my victim advocate has spoken to the victim, and she does say that she reiterated that she was not the one that called the police. She stated that she didn't want to be listed as a victim in the case. And so she didn't state to my victim advocate about she wanted to dismiss, but she did state that she did not want to be listed as a victim, and she is not the one that called the police. The case has been continued previously. It was first on the calendar on May 16th, and then, continued to today. I'm not going to really address Mr. Rogers talking about how police officers should not be allowed to go on training or take vacation. Because, all of us at some point in time, we should not be just held to our job. But the officer did file what he needed to indicate he had annual leave. But again, this case, it has been on the calendar previously. And the victim did indicate that she did not want to be listed as a victim.
Okay. There's, just for the record, since January 1st of 2021, I think I started this job, I've taken exactly 1 day off. And I understand what you're saying, Ms. Freeman, and I disagree with you, Mr. Rogers, about the fact that life happens and people gotta take what they can take. If we had more judges, I'd be taking my time and going to the beach.
Excuse me, Your Honor.
Yes, sir. Yes, sir.
I would take issue with the characterization that I've said people are never supposed to be able to do something like go on vacation or do training. That's not what I said. What I said is that if they're going to arrest people and then extend their detention repeatedly, like, we all have jobs, we don't all lock people up and deprive them of their freedom and lock them off in cages. So it's not the same thing. To whom much is given, much is expected. With great power comes great responsibility. I don't have the authority to snatch Mr. Curry off the street and put him in a box. So it's a difference.
No, which I
Well, Judge, at this point, and I hear what Mr. Rogers is saying, but at this point, I would just ask the court to just based on both of our arguments, and I know it seemed like you were starting to make a decision, but just
yes, I was at the point where you're gonna win, Miss Freeman. I'm gonna continue this case. But what I'm gonna do with you, Mr. Rogers, is I'm gonna put the harness on your neck to seek a bond reduction for your client. Because the arguments that you're making are, in my opinion, are basically for, hey, this person bond need to be lowered so this person can get out of custody, and we'll deal with it as we move forward. It's not a person didn't do it, person did it kind of argument. So I'm willing to meet in the middle and sign a bond reduction.
Judge, I don't even know if a bond reduction was the issue, because I had offered a total of $5,000 on the bond.
Okay.
So.
Yeah, I'll speak with Mr. Curry to see if he would like to go that route. But
well, that's Mr. Curry. I'm going to deny your lawyer's request to dismiss these charges at this time, based upon the officer being on leave. But if your lawyer brings either a consent order or something, files a motion for a bond, I am perfectly willing to reduce your bond to an amount that you can get out of custody. But I need you to understand, Mr. Curry, as I look at these allegations, I don't see you as a good bet to be on bond without something attached to it. And that's just from the allegations alone. It has nothing to do with you personally. But I am responsible for the decisions that I make, and I have to go to bed at night, every night, knowing the decisions that I've made and why I've made them. So I'm willing, Mr. Rogers, to reduce his bond down with conditions, and if through your conversations with Ms. Freeman, hold on, through my conversations through your conversations with Ms. Freeman, if you haven't reached that amount or level or the understanding, that may be something that we just have to have a hearing on or a conversation about. Okay, Mr. Rogers.
Yes, sir.
Mr. Curry, it sounded like you wanted to say something to me.
Yes, sir. When it comes to you saying making decisions, I just wanted to be understood that I haven't been in any trouble or had any violent charges in my life until here recently. And I assure you it's a misunderstanding, but I want you to also know I have a 19-month-old son. I have my Talora, the victim is the mother of my child, and her car engine just went out.
Judge, at this point, this is information that he needs to be speaking to Attorney Rogers about, not.
And I understand, Ms. Freeman. But I do want to give people the opportunity to speak. Sir, you can't talk about the facts of your case. You cannot.
That's about my baby mother's current situation, Your Honor. You feel
So stop. Stop. What you need to understand, Mr. Curry, is that with these charges, it doesn't matter what your baby mother thinks. The state, meaning the district attorney's office or the solicitor's office, they have to look at the charges and make a determination as to what they believe is appropriate for public safety. There been my career, I've had over 30 death penalty cases. And there have been people that have been killed by family members of friends that they were standing up in court saying dismiss the charge. So the state has a different obligation. They have to look at what's being alleged and they make their determination as to how this is going to go. You have a lawyer. Ms. Rogers is a very good lawyer, and speak to Mr. Rogers and try to figure out how to maneuver yourself through this. Okay.
I have, and my baby mother spoke to the DA and wrote affidavit in my behalf, which isn't being read today. I'm not sure why. Referring to the allegation.
Okay. Let me stop you again right there. Let me stop you, sir. It's not because what I'm telling you is what you're saying is invalid. It's just this is not the proper forum for that. And I don't know who called the police. I don't know what happened as it relates to that. I am perfectly willing, Mr. Rogers, to reconsider his bond amounts. So that's an avenue that's available to him. But sir, I'm gonna continue this case.
Judge, and also before you put the defendant in a breakout room with Attorney Rogers, because the other two cases also belong to Attorney Rogers. And so what I would suggest, just for judicial economy, if the court is leaning towards granting a continuance for those cases also, if you could give just a little inclination, so then that way, if Attorney Rogers needs to.
Well, I'll speak. I'll finish with Office and Milliner. And we'll deal with more, and I'll place Ms. Rogers in a breakout room with Mr. Curry. So at least we can try to end this day.
All right, so with Office and Milliner, did you already make a decision on those two, Judge?
No, I'm leaning one way or another, but I want to give an honest hearing and opportunity. So can we, Mr. Curry can go back. Can we have Mr.
Well, not necessarily go back, Judge, because remember, Attorney Rogers is going to speak to him about the bond issue.
Oh,
yes.
And
so that's why I was saying that if you're going to give Attorney Rogers an opportunity to speak with his client, because he also represents Milner in Office as well.
I do know, and we're at 4 after 4 right now.
Judge, if I could, at least see if Mr. Curry wants to see about it.
Okay, hold on. Bring Mr. Curry back. What was your question, Mr. Rogers?
I'm sorry, I couldn't quite catch that.
Well, I was saying, it sounded like you were saying you wanted to either possibly just say something to him quickly, or
no, I was just saying, I wanted to just speak to him in the breakout just to see if how he wants to handle as far as does he want to wait till the content. Like, I just want to see what he wanted to do if we could get it handled this morning for him as opposed to having to wait, this afternoon. So I just wanted to talk to him to see. There might be something we can do.
Oh, okay. So, Mr. Curry, I'm gonna ask the deputies to kind of place you aside so that you can have an opportunity to speak to Mr. Rogers. And you all may reach an agreement today based upon what I said, or you may not. But he deserves that opportunity to be able to speak to you. Okay. All right. Milliner or office?
Your Honor, a judge,
Yes, sir.
I'm not gonna have anybody to escort Moose back to the house. Is there a way you could take care of her real quick for me, sir?
Yes, sir.
I don't have nobody to
Yes, sir.
escort her back.
No, yes, sir. You're there. I'm not there. That's a reasonable request. Bring up
Yes, sir.
Miss Moose.
How are you, Honor?
Miss Moose, how are you doing, ma'am?
You doing okay? How about yourself?
I'm doing well. Thank you for agreeing to come forward. My understanding is that you and Miss Hurd have been in custody since November and have not been assigned lawyers. And based upon that, I'm gonna set a bond of $10 on each count. And it's gonna be a little higher with the sheriff's office having to add fees to it. You Miss Hurd should not have been in custody as long as you've been in custody without having lawyers appointed. And I thought I continue you to today from last month because I wanted to keep my fingers on it. So the state may decide to do what they're going to do, and they have the right to bring charges within I think 4 years and maybe 6 years for some counts. But I'm gonna do an order and it'll get sent out today. And you can contact your family and tell them to start trying to make arrangement.
Thank you, sir.
Do you have any questions?
No, sir, I really don't. I appreciate you. I've been here going on 8 months without being seen, heard, talked to. I had filled out an application, still nothing. Every time I come, I get recontinued. So I was feeling a little discouraged today. That's why I refused to come today, sir. Feeling humiliated just to come to court, just to sit here, just to be sitting in the cell and just feel a mockery of myself. But I do appreciate you.
I'm sorry. I've been on the bench. Been doing this since 7 o'clock this morning. So you shouldn't have to say that. And you should not have been placed in this position. So I
Yeah.
don't know how your charges are gonna work out. I don't know how this position of your case is gonna work out. But I'm doing what I can do. So you still need a lawyer. You still qualify for a lawyer. And I'm gonna be making some angry phone calls about you and Miss Hurd and the position that you're in. But you get a lawyer, pay attention to the lawyer, listen to the lawyer, let the lawyer help and lead you to your case. Okay, ma'am?
Yes, Your Honor.
Okay. Is there any other questions?
No, sir.
Okay. You're free to go back, ma'am. Thank you.
Who you want, sir?
I think we're at Milliner. I think we dealt with
This office in Milliner that we have left, Judge.
okay, we didn't deal with office yet.
No, the co-defendant office with the drug case was represented by Mr. Schoolcraft, and he did a consent bond. But we
Okay.
still, but I don't have the officer on office or Milliner.
And Mr. Rogers is back. Okay. So I do apologize. I hate when things don't work the way that they're supposed to work. And people are kind of left to suffer that. Sir, are you Mr. Milliner? Okay. For the record, this is going to be position 85, State of Georgia versus Jawaria Carmian Milliner. And Mr. Milliner is charged in warrant number 2022 CW 51411 with committing the offense of battery. Mr. Milliner, there's an issue with the officer not being available. Your lawyer has made a motion to dismiss the charges. And
Right, Judge, this is the one where the officer is no longer with CCPD.
oh,
Right, right, and so and this is one where we would have to. I know Ms. Burrell had tried to get in touch with who would have been the supervisor, but she wasn't able to do that, to my knowledge, and so that's the issue with this case. This officer is no longer with CCPD, and so we would have to try to find a supervisor, someone else to testify.
and you said there was an aggravated assault charge also that was not.
There's an aggravated assault, as well as the battery. The battery case is the 1411 and ag assault is 1410. I'm not sure why the ag assault didn't make it on the calendar. And this is one of the cases where we have been in contact with the victim, who wants to go forward with prosecution. And so that's another reason why I am asking that to be rescheduled, and ask to give us an opportunity to see if we can get a supervisor, someone else who could testify in place of this officer who's no longer with CCPD.
But can you make the case with the alleged victim?
We could, Judge, but typically unless we have to, we don't like to have the victims testify at this stage, because then they may have to testify during trial, if it goes trial. But if we had to get the victim, based on what she stated to our victim advocate, she would testify.
Which is something I understand, and I'm saying if the case has been continued before,
No, this case, I don't think this case has been continued. Has it, Mr. Rogers?
Not to my
I don't have a record of a previous date.
Yeah, I would say not to my knowledge, it has not been continued. I will say Mr. Miller's
Right.
been in for the 15th, so I'm not sure why this would have been his first time for a prelim because he's been in since April 15th.
since
Yeah,
April.
it hasn't been on, this is the first time it's been on the calendar.
Is the alleged victim, is this something where it's like family violence? Where there's one plea?
Let me see.
No, sir, they don't live together. As far as the alleged victim of Mr. Milner, they do not live together, don't have any child together, anything like that, to my knowledge. They're acquainted, but Mr. Milner does not intend to be acquainted going forward. But no, they don't child. Yeah, and I would also
Okay,
point.
do you go ahead, Mr. Rogers?
I was just going to point out that, again, I would adopt the same arguments that I made regarding Mr. Curry's case as far as from a general standpoint. Additionally, I would also say that in this case, the alleged victim, per the officer's report, did not even report the crime until 24 hours after. So to the extent that there's some sort of, I guess, personal safety concern or something of hers that she has, that's belied by the fact of waiting 24 hours when you're saying the person left on foot. You could have had them picked up by law enforcement. They're leaving on foot in the middle of the afternoon. And you wait 24 hours to report anything. So I would say that to the extent that anybody is concerned with their safety, that's just belied by the sequence of events. Additionally, there's a lack of any real corroboration for any of these allegations, John. Between the fact that Mr. Milner's been in that long, that the state is essentially asking for an unspecified continued detention at this point. And like I said, the lack of physical evidence to corroborate it, like there's charges, but there's no, as far as the allegations themselves, there's really no physical corroboration of anything that's being alleged. So for the fact of him being, the fact that the state is essentially, the 15th of April, that the state is essentially asking for an indefinite detention, and the fact of the lack of concern expressed by the 24-hour delay in reporting this alleged incident. For all those reasons, John, I would ask that the case be dismissed from one prosecution.
Okay, I am actually inclined to grant this motion. With the officer not being with CCPD anymore, or Clayton County Schools, correct?
No, Clayton County Police Department, CCPD.
Okay. I'm gonna grant the motion to dismiss Ms. Rogers. That means you're gonna have to do some legwork and present an order for my signature, and I'll sign it. And Mr. Milner, what you have to understand is that the state has the ability to bring these charges back within 4 years. And if they can go directly to a grand jury and they can indict the case. And if they do so, these charges will be brought back. Okay, let's.
Thank you, Judge.
Thank
And
you,
I think the next case is office.
Office, yes.
Mhm.
Let's bring up Mr. Jerome Office.
And Judge, this is a case with Detective Fleming, who has been out on leave beginning May 19th and ends June 6th.
That is June 6th. Okay.
Yes, it ends on June 6th. And I believe that this is the first time the case has been on the calendar.
Yeah, and I would still be asking for a dismissal as it relates to Mr. Office. He's been in since April the 23rd. based on what I'm looking at on the sheriff's website. Additionally, I would point out that this was an unlawful detention from the beginning. I would note that Mr. Officer is alleged to have been the driver of a vehicle in this case, but you'll notice there are no charges related to either the vehicle itself or the operation of the vehicle, because this was an unlawful detention from the very beginning. So I would just ask that the court not further add insult to the injury of the unlawful detention. Now, there was no reason that the officer offered for stopping Mr. Office in the first place. And now he's not even here to justify what really can't, I mean, he doesn't really have any justification for the detention. The search is questionable at best, even if the detention wasn't unlawful, which it definitely, the officer does not even.
So hold on. Let me stop you, Mr. Rogers.
Yes, sir.
I think you used the term unlawful detention 3 times.
Right.
Can you describe what you believe to be
Yes, sir.
the unlawful detention?
I'll read actually what the officer alleges, that he stopped Mr. Office because Mr. Office had a tag that said test drive. And because he had heard that there had been thefts in the area. He does not say that the vehicle that Mr. Office was driving was the subject of a theft. Does not say that he observed any sort of moving violation. He mentions the test drive tag and his fact and the general knowledge of an uptick in stolen vehicles, but does not say that there was anything about this vehicle or any recent thefts alleged in that area. And he's not offering any basis as to why he's bothering Mr. Office. And then, like I said, he does not allege anything as far as taillights out, no left turn, like failure to signal, none of these tic-tac things that they normally use as a pretext to bother people. He doesn't even go that far. And that's what I mean, is that this is an unlawful detention because there's no basis to stop the vehicle that Mr. Office was in. And not
Hold on, slow down, Mr. Rogers.
Yes, sir.
Let's engage in a conversation.
But just for clarity, what the officer said in the report is that he observed a white Cadillac ATS without a tag, but a piece of paper stating test drive. And so I just wanted the court to understand, he said that he didn't have a tag. And I'm sure the court is aware, normally when you test drive a car, there's still a tag on the vehicle. And that was the reason, that's in the report. Again, I don't have Officer Fleming here to question him, but just reading what's in the report.
Yeah, I just test drove a vehicle.
Hold on, Mr. Rogers and Ms. Freeman. Ms. Freeman is going where I was going to go with you, Mr. Rogers. Where did the alleged test drive tag come from?
I'm not sure what you mean.
Well, my current understanding is that state of Georgia doesn't really do that anymore with these little, as we would call them in my day, drive out tags or whatever. But if it's a drive out tag, or if it's a tag that's a temporary tag, there's lettering, there's certain things that have to be done, to the extent that, you know, I've seen a bunch of cases out of Texas where people are buying the temporary tags or whatever out of Texas for their cars here. So that's what I'm saying about, I need information. I don't need word.
I understand, y'all. Like I said, the tag says test drive. It's not to say it's not a tag. I mean, yes, in the sense of it says test drive. It's on the vehicle, but there's no basis being alleged to say that there's anything problematic. And let's be clear: once the officer actually does check the vehicle out, everything comes back. There's no problems with it, and there's no allegation.
Okay, stop, Mr. Rogers.
Okay.
Again, I need information and not words. What is it that you're aware of that says that the tag that was on that car was A-okay?
I mean, without having laid
Judge, I
my,
will indicate this in all fairness, what the report says is the test drive tag had a Jim Ellis Auto Motors group name attached to it. The defendant did state that his insurance and vehicle information was at his residence. And so upon further investigation, as Mr. Rogers indicated, that information did check out. So
Okay,
the court is aware.
and, Your
okay,
Honor,
go ahead, Ms. Rogers.
and to come back to the tag question, Your Honor, my point is that there is a lack of probable cause. The officer does not articulate any basis to suspect Mr. Office of wrongdoing. Mr. Office doesn't have to prevent the officer from generating a hunch about him for him to be free to move about. And so that's what I mean is that this tag, there's nothing, the officer does not allege any violation of the tag. Like there's nothing charged. So the officer has not alleged such a violation or even any basis. He doesn't even offer that as a basis. And in addition, as Ms. Freeman just pointed out, everything was in order. So it's certainly not that he received something to the contrary. So for those reasons, John, I would say that the fact that the officer fails to allege the basis for stopping, he doesn't allege that the tag was improper. He does not allege that Mr. Office did anything that would give rise to him being able to stop Mr. Office. And then once he does stop Mr. Office unlawfully, because again, Mr. Office doesn't have to offer a justification. The officer needs to offer a justification for why he is stopping Mr. Office. That hasn't been done. And then once he checks the vehicle out, that concern is dispelled. The other person arrested was arrested about a warrant that's not even related to Mr. Office. So there's nothing that they would have known in advance to justify stopping Mr. Office in the first place. That the officer, like I said, that he doesn't even allege anything like that. Not charged with anything, any improper display, nothing.
Okay, Ms. Freeman, you've heard Mr. Rogers' argument that there is no basis for the detention. Do you have a response to that?
I mean, Judge, without my officer here, the only thing I can tell you what's in the report is that he indicated that the test drive on the piece of paper is what drew his suspicion because of the uptick of stolen vehicles in the area. I don't have the officer here to ask anything else about, and so I'll have to stand on that argument and ask that it be rescheduled.
Okay. All right, I'm gonna dismiss these charges against Mr. Office for warrant of prosecution. And Mr. Office, the state is free to bring these charges back if that's what they want to do. And that should conclude what we have going on today. Is that correct?
And that's correct, Judge, unless I don't know if Mr. Rogers was supposed to be talking to Mr. Curry.
Yes, ma'am.
On issue.
He does.
If I could just pop into a breakout room with Mr. Curry, please. Thank
Okay,
you.
Mr. Office, your charges are gonna be dismissed.
Thank you,
We
John.
gotta go through a process to have that happen. But it will happen.
And Judge, we're still on YouTube also.